I'm Colin O'Keefe, and this is LXBN TV. The Sixth Circuit Court of Appeals recently ruled that Wal-Mart's firing of an employee with sinus cancer and an inoperable brain tumor for his medicinal marijuana use was lawful. To discuss the case, we bring in Sara Hutchins Jodka of Wright and their blog, Employer Law Report. Sara, first, can you explain for us the background of the case and how the court arrived at its ruling?
Sure. Well, as you indicated already, the facts are relatively simple. This was an employee of Wal-Mart who'd been working there for a few years, and he had been suffering from sinus cancer and an inoperable brain tumor. And during the course of his employment, the voters of Michigan, by referendum, voted into law the Michigan Medical Marijuana Act, which is the MMMA. He was then given a prescription by his doctor, put on the medical marijuana registry, and then he was allowed to have a marijuana card and have medicinal marijuana. So he starts taking that, and then he gets into a workplace accident. And pursuant to Wal-Mart's policy, he was subjected to a drug test. And as we know, the drug test came up positive, and corporate Wal-Mart said, well, he's got to be fired. So his supervisor had to hand down that termination decision, and he sued. So at the district court level, and these were the same issues at the Supreme Court level, or the Sixth Circuit level rather, there were two issues. The first was, did this violate the express provisions of the MMMA themselves? The second was this a wrongful termination in violation of Michigan public policy enunciated in the MMMA statute? This was a case of first impression for the Sixth Circuit. And what the Sixth Circuit did was it first looked at the statutory issue, and it came down to statutory interpretation. There was one key issue that they had to look at, and that was how was the statute interpreted? And there was one word that really the decision hinged on, and that was the definition of the word business as it was used in the statute. The way the statute was written, it was written as basically, you are not allowed to take any type of adverse employment action against a registered user. And this applied to, and here's how the statute was written, businesses or occupational or professional licensing boards or bureaus. So the key there was businesses. And the plaintiff in the case was trying to argue that this term business should be read in isolation as to apply to all businesses were then prohibited from taking adverse actions against registered users. This would apply to employers, he argued. Wal-Mart argued that this isn't isolation. This is a term that is used to modify licensing board and bureaus, just like the other terms are used in the statute of occupational professional. Well, the Sixth Circuit decided with Wal-Mart and said, we're reviewing this in terms of statutory construction. We have to review the way that this word business is used in the whole context of the statute and the way it's written in relation to all the other words. These were all joined by the word or, business, occupational, professional. It meant to modify licensing board or bureau. And based on that, the Sixth Circuit said, this doesn't apply to employers. This act is not extending this to the employment law context. This is basically a criminal statute.
And second, what are the takeaways for employers following this case?
I think it's very important for employers to be very cognizant of their drug and alcohol policies. Their express prohibitions against illegal drugs in the workplace. And with that, I think it's equally important that they review their drug and alcohol testing policies in the workplace. And for employers to be able to catch this type of conduct, they have to ensure that their drug and alcohol testing policies comply with state law. And each state has, completely different laws on the issue. And so this is one area where employers really need to make sure that they are complying with law, whether it's a strict law like we've seen in Maine and Connecticut, or whether it's more relaxed like the ones we have here in Ohio and other surrounding states. They need to make sure that they're complying with the laws and complying with the privacy protections that the states, by case law, have extended to employees. And lastly, it's important for HR to be properly trained on these types of issues. It's one thing for an employer to have a policy and a very well crafted policy. It's another to administer that policy. And employers really need to make sure that their HR employees and that their supervisors are trained in these types of issues and how to proceed accordingly.
Once again, that was Sara Hutchins Jodka of Porter Wright in their blog, The Employer Law Report. For more of her insight on the case, be sure to visit employerlawreport.com, and for more curated commentary from Alex Blog Network's thousands of authors, visit us at lxbn.com. Thanks, Sara.
Thank you. Bye.